Hi, I'm Carrie Felice, Probate Department Chair at Elder Needs Law. Having a will is always a good idea. However, if you have a loved one who passes away, just because they have a will does not necessarily mean you will need to open a probate. When might a will not need to go through the probate process? Well, the most obvious would be if your loved one has no probatable assets. This usually occurs when everything they own jointly with someone else. We see this a lot when someone is survived by their spouse. If the house, the cars, the bank accounts are all owned jointly by the spouses, they'll all pass automatically to the surviving spouse without the need for a probate. Even if your loved one's accounts aren't owned jointly, if they have named beneficiaries or a designated payable on death beneficiary, those assets will pass automatically to the beneficiary without the need for a probate. Real property owned as joint tenants with rights of survivorship, generally with someone other than your spouse, will also automatically pass to the co-owner or owners without the need for a probate. Also, real property that you hold a life estate in will pass automatically to the Romain German without the need for a probate. Now, another reason your loved one's assets may not be subject to probate is that they're considered exempt property. We see this primarily with motor vehicles. Florida Statutes provides that the surviving spouse, or if there is no surviving spouse, the children are entitled to transfer ownership of 2 motor vehicles free from creditor claims and without the need for a probate. You can usually just take your loved one's death certificate and a will, if there is one, to the DMV, and they'll transfer the titles for you. Now, in the absence of a will, the DMV will likely have you sign an affidavit of heirs in which you detail under oath who exactly is the surviving spouse and who all the children are. Now, while homestead real property is also considered exempt property and technically transfers to the heirs outlined in your loved one's will or outlined in Florida statutes, an order stating that the property was homestead and did transfer in that particular way needs to be signed by a probate judge in order to establish in the chain of title for the property who exactly the new owner is. So therefore, in the case of homestead real property, a simplified probate process will be required unless it's owned jointly with survivorship rights or owned jointly with the spouse. Finally, your loved one's estate may not require a probate, even though they have a will, if they also have a trust and all of their assets have already been transferred into the trust. Determining whether you will need to open a probate for your loved one's estate can be determined in consultation with a probate attorney by reviewing your loved one's wills and all of their assets. So if you would like to discuss whether a probate is necessary to distribute your loved one's assets, call us today to schedule a probate consultation.